My name is Richard August, and I'll be your host. Our guest is Dane Ardente, an attorney with Kelly Sousa and Parmenter, LLP in Providence. KSP Law represented the plaintiffs, a firearms dealer, and several gun-owning citizens who filed a challenge in federal district court in the large capacity magazine law enacted in June. Welcome to State of the State.
Thank you for having me, Dick. My name is Dane Ardente, as you stated. I represent the plaintiffs in this case, Ocean State Tactical, also known as Big Bear Hunting and Fishing Supply, Mary Brimmer, Jeff Goyette, and Jonathan Hirons, and Jim Grandi.
Right. On December 14th, Chief Judge John J. McConnell Jr. handed down a 59-page ruling on a motion to grant a preliminary injunction that would temporarily block a bill signed into law by Governor McKee in June that requires anyone owning a, quote, detachable ammunition feeding device, otherwise known as a high-capacity magazine, or in the judge's parlance, an LCM, to sell it to a federally licensed dealer, transfer it to someone in the state that allows them, or turn them into the police no later than December 18th. Failure to do so subjects the owner to a felony charge carrying a fine of $5,000 and or 5 years in jail. Mr. Ardente, tell us again who the plaintiffs are and why they felt it necessary to file a suit in federal court as opposed to, say, a state court.
Yeah, so the plaintiffs in this matter, I kind of want to designate the plaintiffs into two different classes of plaintiffs. We had part of our strategy, and part of the real issues were that we had our individual plaintiffs who were just individual citizens, who was everyone but Big Bear. And then we had what we called in our briefs the business plaintiff, who would be Big Bear Hunting and Fishing Supply. The two reasons for that, Big Bear as a business plaintiff did not have what's called standing to challenge the high capacity magazine ban as a violation of their Second Amendment rights, because as you stated in the statute, FFLs, or federally licensed firearm dealers, were exempt from this ban. However, the individual plaintiffs as citizens who weren't FFLs had what's called standing. In other words, in legal terms, they had an injury that was posed by the statute. So they had high capacity magazines that they would have to turn in or be subject to criminal penalties. The reason we had Big Bear in is for our Fifth Amendment takings clause claims. The argument was that Big Bear would lose a substantial amount of business and be unable to sell their inventory to Rhode Island residents. The state was saying, well, they can sell them out of state and establish an online wing of their business. And it's one of those things where, some businesses aren't equipped to do that. They don't have the resources to do that, or they're just too small. So it took away a big swath of their inventory. The reason we filed this in federal district court as opposed to state court is these were federal issues, number one, so it probably would have been removed anyways, but these issues were we thought, complex enough where a federal district court would be more equipped to handle it.
Okay. Now, a member of our audience provided information indicating that Judge McConnell is an active financial supporter for groups known to be anti-Second Amendment. Were you aware of this, and was Judge McConnell asked to recuse himself based on that?
No, I was not aware of this, and frankly, it's been a rumor that floats around. I have no information on that, so I don't want to make assumptions on that.
Right.
But there was no talk of recusal, and there was nothing brought to our attention at the time.
If this were brought to your attention at this point, is it proper to enter it as part of the appeal?
I think at this point, if it were brought to me with, kind of something conclusive and definitely determinative, we would have to discuss it.
Yeah.
I'm not sure if it would be a part of the appeal. Right now, the appeal is based on the merits. It's based on the fact that we truly believe there are constitutional violations here. And I think, quite a few people, including other than the plaintiffs, feel that way too. Even if you're not a Second Amendment person, this is largely a Fifth Amendment taking argument. In other words, the government can't take private property for public use without providing just compensation. Part of Judge McConnell's decision was that, well, the ban on high-capacity magazines is exempt from a takings claim because it's an exercise of the government's police power.
We're going to get to that because that's a really important fact.
I'll save that one for your questions.
But Judge McConnell found that the plaintiffs would not suffer irreparable harm if the law is allowed to take effect. Could you explain for us the term irreparable harm and what was the judge's reasoning on that?
So let's back up a minute and just kind of, in order to answer that, I'll kind of go through the actual elements of a preliminary injunction. So a preliminary injunction, for those who don't know, this was kind of a unique scenario where the merits were almost determined at the injunction stage of things, where that's not always the case when you're going for injunctions like that. So in other words, what happens when you ask for an injunction or a temporary restraining order is that you have not yet concluded. Some of these cases can go on forever. But in a lot of cases, the harm that could be done if whatever's happening keeps going until the end of the case creates what's called an irreparable harm, where it could be there's so much harm done by the time a decision is reached on it. It's
a moot point.
It's a moot point, essentially. A lot of these, the perfect example is environmental cases where you have I'm just thinking of a hypothetical. You have a corporation who's accused of violating EPA laws against pollution into a river. What the plaintiffs will do, say the plaintiffs are an environmental group, what they'll do is they'll file the action, but then they'll go for an injunction, and it'll basically ask the court, hey, you really need to stop this right now prior to a hearing on the actual merits of the case, because the pollution is still ongoing and it's very damaging. So that's one element to it: irreparable harm, a balancing of the equities, and a likelihood of success on the merits, which is the most important element. And it's basically showing that there's a good chance that you're going to succeed on these merits.
Okay, so the parties, particularly the plaintiffs, are the ones bringing the action, would suffer some financial or other harm because it's going to take the court a while to hand down a final decision.
Yes.
So in the meantime, the court, please prevent this law from coming into effect.
Yes, normally. But what was interesting about this case is the irreparable harm was the drop dead date of December 18th for turn-in.
Right.
Clearly, there wasn't going to be a decision issued before December 18th. So you have people, and this was part of the issue with trying to explain this case to people, is that they're like, well, how much does a magazine cost? Well, $15 roughly, a high-capacity magazine. Some people have a couple hundred of them. And this is lawfully acquired private property. Mm-hmm. So if you're a law-abiding citizen and you want to conform your conduct to law, you were going to have to turn in your magazine before there was a decision issued on this. And it was likely that you probably wouldn't have gotten that property back. And this is lawfully acquired property. This isn't something that you're not supposed to have.
It wasn't contraband until the law went into effect.
Yeah. I mean, you or I, and I'm sure you did as well as I did, you could walk into a gun store prior to the enactment of this, and you could buy 20 of them if you want.
The gun store that you referred to, known as Big Bear Hunting, I think, like most firearms dealers, had perhaps hundreds or maybe even thousands of these that are now contraband. And one dealer told me that the high-capacity magazines supplied with all of the modern sporting rifles and handguns in his inventory could not be returned to the manufacturer and would have to be sold at a discount probably on the internet, and along with all the magazines they have in stock. Mm-hmm. So I think you whatever average cost you want. I know some of them cost probably $40, but let's say even at 15, if you've got 1,000 of these, you've got, of them. It seems to me this is irreparable harm to a business.
Yes, it is. And part of the argument with that was that the cost that it's going to take not only to try and sell these things and make up for it, but also to come into conformance. Like you said, when this was passed, almost every semi-automatic firearm that took a magazine in their stock had one stock from the manufacturer. So now they either have to A, sell it without a magazine, or B, they have to replace it with an aftermarket magazine, and that adds cost to the basis of the individual firearm that they're selling.
Sure. assuming you can find one that,
that was the other
has
part.
10 rounds or less, and
Yeah.
it may not be possible in some cases. Now, Judge McConnell invoked a list of mass shootings in arriving at his decision, I think in order to comply with the guidelines in the Bruin decision. And he opined that, I'm going to quote him, "The LCM ban is a small but measured attempt to mitigate the potential loss of life and is consistent with the legislature's obligation to protect public safety." I think we started to talk about that. What evidence was presented that would lead him to that conclusion?
Well, you know, it's tough to say because everything's a balancing issue in this case. And is the banning of LCMs going to have any discernible distinction on crime rate and maybe even homicides or injury? Maybe, but it's a maybe. But also, what's the harm done?
Potential loss,
Potential, maybe. But what's the harm done in taking people's property without providing compensation? As we were talking about before, what does that do down the road? Where now the government basically has the green light to regulate whatever it wants under police power, where they say, well, it's injurious to public health and safety. Well, there's a lot of states that don't consider high-capacity magazines injurious to public health or safety. Actually, quite frankly, most of them. So now you have a real difference in what states think is good for the health of their people. So, I mean, it's an issue in the sense that how are we measuring this?
It seems another analogy perhaps that our audience can relate to is, let's say we have a spate of motorcycle accidents, fatal or even very serious injuries result, and so a group gets together and says we have to ban motorcycles because they really have no practical use in our society and they're dangerous, and therefore we're going to outlaw them, and everybody who owns one has to dispose of it, turn it into the police, sell it to somebody else, that's the same thing, isn't it? And they're not being so that's maybe you're saying, well, that's got a lot more value to it, but the value isn't the question here. It's the principle of the taking without compensation.
The principle, and it's also the slippery slope argument. And I don't want to sound like I'm overstepping with this, but it's just how far is this going to go, and what are the implications that taking away another freedom like this are going to have? That's the issue.
We had on this program the sponsor of the ban in the House of Representatives, who is now our new Secretary of State, Greg Amore. I asked him off camera where the magic number of 10 came from. Is a 10-round magazine safe, but an 11-round magazine lethal? And he could not answer. It's interesting, Mr. Ardente, that New York State says no more than 7 rounds. Colorado says 15 is okay. Vermont says, oh, you can have 10 in a rifle, but 15 in a handgun. Was there anything introduced in any of the written testimony that supports or explains where this idea of a 10-round limit came from?
I would have to re-review it, but it was kind of a piggyback off of other states. California was doing the same thing. I believe Massachusetts was doing the same thing at the time. So it was kind of this, and it was interesting because a lot of the states that were enacting these bans at the time, it was almost like a cookie cutter legislation. It was kind of the exact same language in each state. I want to say it was California, Rhode Island.
It's frequently used. I mean, it seems like this is one of the mantras of these groups that want to control firearms. That 10, for some reason, became the magic number.
Exactly.
So I'd like to know what's the genesis of this. How did this come about? But obviously, there was nothing that you recall that was actually would be supportive of the limit itself.
Not that would say 10 over 7, rather than 7. Here's why 10. More just a reduction in. Because before the magazine ban, there was no limit as to capacity. So I think they just took it into some kind of lowered capacity, some kind of limit, if you will.
Now, a key point in the judge's decision is that no proof was entered that showed that, quote, the magazines represented arms as seen in the Second Amendment. And I saw a pair of Second Amendment attorneys from Texas commenting on social media that this will become a new tactic of the anti-gun movement. In other words, to show that parts of guns are not really guns. For example, a laser sight or a telescopic sight that can be removed. Do you concur with this? I mean, is it more of the slippery slope argument?
It's more of the slippery slope argument, and to be quite frank, I disagreed with that pretty much in its totality. We had presented an expert, and I don't see how it's not an arm protected under the Second Amendment, because the Rhode Island general laws categorize magazines under their weapons chapter of the actual general laws, and this is codified in the chapter for weapons. And as I was telling you off screen earlier, one of our main arguments, and I stick to this now, is that under regulation of arms, there's multiple regulations that say, especially with relation to having a loaded firearm in the car, you can't have a loaded rifle or a shotgun in the car, but you also can't have, they also count it to be the same as if you had a magazine with the ammunition in it. And I believe that it's the same way, even if the firearm isn't
not
in
there.
it.
Sure.
So if you have, essentially, if you have a magazine that has ammunition in it and it's in your car, that's the same thing. You're charged as having a loaded firearm. Oh. So they're charging these as firearms crimes, or at least it's chargeable as a
chargeable. Sure. Judge McConnell said that the high-capacity magazines, and I quote again, easily convert handguns into semi-auto weapons capable of rapid fire. Isn't every handgun capable of rapid fire, whether it's got a high? I mean,
yeah. Essentially. I think he may have misstated in that one. I'll give him the benefit of the doubt on that. But yeah, I mean, it doesn't do anything. It doesn't change the functionality of a firearm at all, right? At all, in any way. It's just a matter of how often does one have to reload.
He also accepted the opinion of a state witness that high-capacity firearms are historically understood to be weapons of war. Who was that? Who was the witness? Was it someone from the military, or?
I don't remember what witness. That might have been the witness from, I believe he was a Brown University professor. I'd have to touch up on re-review it. But regarding that statement, it's just not true. And this goes back to what we were talking about earlier. And I don't know how much you want me to get into Heller, but the decision of D.C.
Heller's decision, a Supreme Court decision, that was a landmark case.
So Heller was backing up. Heller was before Bruin, and Heller was kind of the landmark case for these Second Amendment claims. And one of the most important things of Heller that was established, and it was kind of just a reinforcement, it wasn't necessarily an establishment in Heller, but it was categories of firearms regulations that have been deemed to be outside of the scope of Second Amendment protection. So you have firearms regulations that are within Second Amendment protection, where the whole shall not infringe thing comes to be. And then you have firearms regulations that are not protected by the Second Amendment. And there, I believe, were 4 categories. One of them is felons in possession of firearms, the mentally ill, what's called the sensitive places doctrine. So carrying of firearms in sensitive places, such as a school or a bank, for obvious reasons. And then the prohibition on dangerous and unusual weapons that were not in common use at the time. So getting back to your question regarding the fact that high-capacity magazines are weapons of war, I equate that to, let's take, for example, a real weapon of war, an M16 or any automatic rifle. Those have been declared by the Supreme Court to be dangerous and unusual weapons, and partly because they're not in common use. There's not many people who had these when they were legal, an M16 or, like you said, a Tommy gun. High-capacity magazines are extraordinarily common. It's
millions of them.
It was hard to really establish a number because there are so many of them. Because, like you said, most modern semi-automatic firearms have them. I mean, we were estimating. I was trying to count in the hundreds of millions. And I think even back in '94, it was still upwards of probably close to 100 million. So what that tells me is that these aren't dangerous and unusual weapons. These are very much so in common use. And there was actually a case in New York that, in the district court in New York, I believe it was New York State Rifle and Pistol Association versus Cuomo, that declared that as well. These things are in common use. It's not, these aren't these uncommon things that everyone thinks just, 1 in 100 has. It's kind of, your standard semi-automatic magazine.
So the example might be that the so-called Tommy gun, Thompson submachine gun, which was fully automatic and fired from a detachable magazine, was available to civilians until it began to be used in crime and with devastating results. So the court said that's a separate category. That's something that falls outside of the protection of the Second Amendment.
Exactly.
Okay.
Yes. Yep.
Okay.
And there was actually a case on that. I believe it was Staples versus the United States. And I can read you the holding from that. But basically, the distinctions were that it was an automatic weapon and it was not the magazine. So in Staples versus the United States, the Supreme Court found machine guns are of quasi-suspect character, the same category as hand grenades, and thus fall outside of the weapons traditionally protected by the Second Amendment.
It's interesting, though, because although those weapons firearms are prohibited, there are people that possess them because they go through a very expensive and time-consuming process with the Bureau of Alcohol, Tobacco, and Firearms. So,
yes, yep.
So there are places in certain states where you can go and actually fire these weapons at a pretty expensive deal, but nonetheless, if you want to experience it, you can, because these people are heavily regulated and have complied with the regulations of the federal government.
Yeah, and kind of an oversimplification of that same statement that you just made is it essentially becomes a privilege at that point rather than a right. The whole argument with the Second Amendment is that it's a right. It shall not be infringed unless due process is given. So essentially what the government is saying is, people may have machine guns, but it's not, nobody off the street can come and buy one.
Right.
It's not your right to have one.
Right.
And that's why they fall outside of the Second Amendment protection.
And here again, getting back to your earlier conversation, the judge dismissed the argument of an unconstitutional seizure of property without compensation, saying the state's exercise of its police power does not entitle the property owner to compensation. And he went on to say, and I'm quoting, "The prohibition was a reasonable response to the public safety interests of the state." Am I correct in understanding that the judge believes that public safety trumps a constitutional right?
So I'll just say, before I answer that question, I'll just say that this was the biggest issue that I personally had with the decision. I don't think this is the ultimate slippery slope, in my opinion. I think regarding your question, it's not so much that he's stating public safety trumps a constitutional right. But what he does, I think, is he over-exaggerates the public safety element of it, if you will, because just like what we were talking about with automatic weapons, a lot of those automatic weapons cases are covered under takings claims too, or they bring takings claims, which also say, well, we don't compensate anyone who has an automatic weapon because it's extremely dangerous to the public. You have to destroy it. And they actually just did that with what's called a bump stock. They classified it under the National Firearms Act also as an automatic weapon and basically said, everybody has to destroy them, and there was no compensation provided. It's a bit of a stretch to say that a high-capacity magazine is in that category, in my opinion.
Okay. I think we said that there was no oral testimony or cross-examination of witnesses for either side. Instead, because this is a motion for relief, presumably temporary relief, while a decision comes down, written memoranda and briefs were the basis of the arguments from both sides.
Yes.
Okay. Now, the state presented a memo from emergency room Dr. Megan Rainey, a well-known anti-gun zealot who co-chaired Governor Raimondo's so-called working group on gun safety. And Dr. Rainey opined that the ability to spray bullets results in more victims and wounds. I guess the question would be, what qualifies her to offer expert testimony on the effectiveness of firearms? She's a doctor, she's not a firearms expert, and even Judge McConnell agreed that her testimony was, in his word, sparse, yet he deemed her to be a credible witness. I find it hard to believe that Dr. Ardente can tell by examining a bullet wound whether it came from a 5-shot revolver or a 17-shot pistol, or if hit more than once, what the capacity of the firearm was. So will this be part of the challenge at appeal, that this logic doesn't seem to follow?
It will be something that's brought up. Obviously, the appeal will be on pretty much the, limited to the record as it is. But kind of in a different way to phrase how I was originally going to answer you is what I would say to Dr. Ardente and what I would say to Judge McConnell in this case, respectfully, is, that maybe, let's assume it's true, that high-capacity magazines might inflict, and I'm saying let's say, that, again, banning them might show a discernible difference in an emergency room. How much, I really don't think it would be all that much. Because, again, these types of crimes are being committed with firearms that are owned illegally to begin with. So, but we'll put that aside. What I would say to them is, well, in that case, how much do you have? I'm guessing you have quite a few trauma cases involving automobile accidents, or how about dirt biking accidents, or how about, I don't know, a sports injury. So that's what I'm trying to say when I get back to that slippery slope argument is, how far are we going to go with public safety when it comes down to people's quality of life and rights and security, that the government won't infringe on those rights? This
seems to me to be one of the problems with dealing with written testimony only. You do not have an opportunity to cross-examine the person making the statements, correct?
Correct, yes.
And again, I want to emphasize that it was a motion to ask the court to provide temporary relief while testimony, oral and written, could be presented and debated in the court, right?
Correct.
And the judge turns around and hands down a 59-page decision replete with all kinds of footnotes and everything else, saying, well, this is the ruling. Not much point in going to trial at that point. I mean, the judge has already expressed his opinion. There's no point.
Yeah, so that gets back to something I started on earlier, and this is a distinguishable case from the hypothetical I made with the Environmental Protection Agency case where, there's some pollution in a river. This really was a case that was solely based kind of on the merits with really nothing else to it, with really no other teeth than the actual decision of, is this constitutional or is this not? There really wasn't any conduct among the plaintiffs that was factual in nature. It was just individual citizens who have these magazines, and they, is this turn-in or is this legislation going to be constitutional or is it not? Does it violate the Second Amendment or does it not? So when those decisions essentially were quasi-made on the merits in the preliminary injunction stage of it, it was essentially a decision on the merits of the whole case. And also the actual date had come and gone for turn-in. So people had to turn in their magazines after the decision was released, essentially.
Now, just to get back to the timeline from the governor, I believe, signed this into law around June.
I think it was June 21st. 21st.
Yep. And your plaintiffs came forward to challenge that around about a week later, roughly.
Yeah, I think we filed.
It was reasonably close.
A week later.
And yet we had a 6-month, 180-day window that we're working with, and the judge waits until 4 days until the window is closed to hand down a ruling. I mean, that doesn't really seem to be playing on a level field.
It was interesting. I will say, in the judge's defense, it was a very comprehensively briefed issue on both sides.
Okay.
Coincidentally, the decision was released on the date of Sandy Hook, the anniversary date. So Whether that played into it or not, I can't say for sure, but it is a fact.
The chief of the Attorney General's Bureau of Criminal Investigation, Edward Triano, submitted a statement that he was, and I'm quoting from his statement, unaware of any incidents in which a civilian has fired as many as 10 rounds in self-defense, presumably. That's not the same as saying it's never happened, is it?
It's not the same as saying it never happened, and it's also not the same as saying, well, is self-defense supposed to be limited to under 10 rounds? I mean, you know, when you think about it from the outset, you think, oh, who would ever fire more than 10 rounds? But, you know, the Second Amendment isn't put there for hypothetical situations. It's a right that people have, and you know, there might be a situation where you have 4 to 5 to 6 assailants. These situations have happened in history, and like you said, I find it hard to believe that there's ever been a case where more than 10 rounds have been used.
Yeah, I guess the point would, I'm not sure what the point is when he says I couldn't find one. Well, how far back did he look? And like it may not be here in Rhode Island, but there probably might be some in Connecticut or.
I think it was the implicit argument of what's the need for over 10 rounds.
The judge did say that he regarded the credentials of Dr. Rainey and Chief Triano, quote, show them to be well qualified to render their opinions. Now, did he expand on that, or again, is this part of the appeal that Chief Triano came from, his background was from the Bureau of Alcohol, Tobacco, and Firearms, and now he is really responsible. One of his areas of responsibility is to run background checks on people that apply for concealed carry permits and so forth. But yet, they were treated as credible expert witnesses on areas that they don't really seem to demonstrate expertise in.
Yeah, I agree. You know, I think their expert testimony as to what they were testifying to, I think I thought their testimony was, you know, in line with what they were testifying to. However, I think the testimony was somewhat inappropriate for a Second Amendment challenge. It just wasn't part of the standard of review, in my opinion.
Okay. Now, the plaintiffs your clients submitted a 27-page memo from, I hope I pronounced the name correctly, Ashley Heblinski?
Yes.
And she's a history of firearms expert from the Firearms Research Center at the University of Wyoming College of Law. And Judge McConnell found her not to be a credible witness. Did he explain why?
You know, he explained why in the decision somewhat. I thought that was, you know, I think that was a little unwarranted. I think Ashley provided expert testimony directly pertaining to the standard of review established in Bruin, which is essentially the historical tradition establishment, which was established in a case called New York Rifle and Pistol Association versus Bruin. It came out in July. And that kind of not changed the landscape of Second Amendment challenges, but really reinforced the standards established in Heller and kind of corrected the district courts that were applying the wrong standard since Heller. So essentially what the Bruin decision said is what was happening before Bruin, post-Heller, pre-Bruin, is that the district courts were essentially applying a two-part test. They would say, number one, is this covered under the Second Amendment and is it historically permitted under the Second Amendment, whatever regulation was being challenged? If they said yes, then they would move on to a second challenge, which was kind of a heightened scrutiny challenge where they'd say, is the government's goal tailored to fit what they're trying to do? In other words, is this something that's going to help public safety even though it burdens the Second Amendment right? What Bruin did is essentially came along and slashed the second part of that test and said, is it in concordance with the test established in Bruin and Heller? And it's part of the historical analysis to it. And Ashley's report was I was going to say primarily, but it was solely commenting on the historical analysis of high-capacity magazines and multiple rounds and
the
kind of
evolution of firearms,
yes,
generally, technological advances that have taken place.
And in this country, and how it was regulated kind of at the founding era all the way through.
It's important, I think, when attorneys refer to cases by name, Heller, in my understanding, and please correct me if I'm wrong, Heller basically was a case involving a resident of District of Columbia who was, I think, a private security.
He was a retired police officer.
Or police officer. Yep. And in the District of Columbia had very, very severe restrictions. And his argument was that he was being denied his right of self-defense because he wasn't allowed to keep a firearm at home.
I believe it was a handgun.
Or handgun,
yep.
Specifically handgun, yes. So what the court said in Heller is, wait, the Second Amendment is not all about a, quote, well-regulated militia. It's about the individual citizen's right of self-defense.
Correct, yeah.
Okay, so Bruin comes along, and what the court said, I think in a 6-3 opinion, if I remember correctly, Bruin was a challenge in New York to the very restrictive laws that they had there in terms of issuing concealed carry permits, and so
which Rhode Island residents can appreciate as well.
Right. And Rhode Island, frankly, was one of the states identified by name in that decision as being restrictive.
What they would call a May issue state, pre-Bruin.
Right. And if I remember correctly, Attorney General Noronha very quickly said, oh, I'm going to take this under advisement, and he came out with a statement later on that it didn't really apply to Rhode Island because the municipal issuing authorities had a shall issue as opposed to a may issue. There's a two-tier. Is that? I mean, I'm summarizing.
You're correct.
Yeah.
You're correct.
Okay.
I'm grinning as to the weight that actually carries and whether that was true or not.
Right.
There were plenty of towns that were very much so practicing may issue.
Of course, and there was many cases argued. Not many, but several cases went to the state Supreme Court about the failure of municipalities to issue concealed carry permits to otherwise qualified persons, and not really explaining why. So that's like the constitutional background to this, and now Rhode Island comes along and says, well, look, first of all, Connecticut and Massachusetts both have high-capacity magazine bans. With an important distinction, they allow those in possession by citizens at the time of the law going into effect were allowed to keep them. Attorney General Noronha, when this was being debated by the legislature, sent a letter saying, if you allow these to be grandfathered, the law is unenforceable. Am I correct?
Pretty much, yeah.
So.
And a lot of members of the General Assembly were saying that as well during deliberation on it.
Sure. But again, we get down to the due process and taking of private property without compensation. The whole thing is kind of intertwined, and I think the public sometimes has a difficulty understanding the nuances of the arguments that are being made. But at the basis of all this, the Constitution, and specifically the first 10 amendments, talk about things that are rights, and they're not conferred by the state. It's not something the state allows you to have. The founders believed that these were God-given rights that we all have inherently. Am I right?
Correct. You're correct.
Okay.
And what you're getting at, without even knowing it, is the 14th Amendment. And what the 14th Amendment does is it confers all of the federal rights granted in the Constitution upon the states. So that was, for people who don't know, the 14th Amendment was enacted post-Civil War, and what it did essentially was kind of a little background. Southern states during Reconstruction weren't necessarily honoring certain classes of people's rights.
Sure.
Even after coming back into the Union. So the 14th Amendment essentially gives a private right of action against a state for violation of constitutional rights.
The judge dismissed the argument that it takes about 2 seconds to change a magazine because those who oppose this bill said that 2 seconds is immaterial in a mass shooting scenario. And the judge kind of dismissed that, and he pointed out several examples, one of them being the shooting involving Arizona Congresswoman Gabby Gifford, in which the perpetrator I'm going to quote, fired 31 rounds, each of which found a human target. And the result was there were 6 dead and 12 injured, including Ms. Gifford. Is that a valid argument in your opinion, that the judge's observation that that's a part of the reason why we should ban these things?
Is it a valid concern? Is it a valid argument? No, I don't think so. Is it a valid concern? Again, it gets back to the question of, is this going to have any discernible difference versus the cost of what it's going to cost in terms of people's rights? I don't know that banning high-capacity magazines would have changed that at all. And additionally, I don't know that someone who's gearing up to commit a crime like that really cares about any kind of regulation on firearms. I can guarantee you they don't. And I think they'll be able to find access to those types of things very easily, just as, and by the way, just as every other criminals in any other country can as well.
Sure.
So.
And actually, on the day before we're taping this, or the weekend before, as you may know, there was a mass shooting in California at a ballroom dancing club. And what has come to light is that the perpetrator in this case, who committed suicide when approached by the police, which is quite common, was a 72-year-old Japanese-American gentleman, and the club was frequented by Japanese-American residents or citizens. So that kind of takes the wind out of the sails of the hate crime aspect of it, because it wasn't a Caucasian or another person, another race that did it. But California has, perhaps after Hawaii, I think is regarded as having the most strict firearms regulations.
I think they're number one.
Or maybe even number one. But I mean, it doesn't seem to make any difference.
And that's what I'm saying. A crime that heinous and a crime that deliberate, I don't see a ban on magazines over 10 rounds stopping something like that from happening. I don't.
The judge quoted an anti-gun group article about the Gifford shooting, noting that, and I quote from the article in front of the judge's opinion, an average of 1.6 bullets hitting each target. I guess it's left to the reader's imagination as to what 0.6 of a bullet looks like, but interestingly, Gifford's husband, now United States Senator Mark Kelly, voted against a federal ban on assault weapons and their high-capacity magazines, which gun control advocates claim are the reason we have mass shootings. So Senator Kelly was one of the Democrats that actually voted against. Just before the end of the year, Democrats put forward another federal ban, and he was one of them that voted against it.
And I think, pertaining to that, I think these gun debates can get into a real position where people get divided into camps of left versus right. And like you said earlier, people don't understand the nuances of this is realistically a property issue. And anyone who's an American citizen should be concerned when the government can essentially arbitrarily take property based on the police powers. Because it can apply to anything at this point.
We said the silly little motorcycle example that I gave.
Motorcycle is a perfect example. And then, I see, I don't see it past reality that in a certain amount of years, there will be a turn-in date for gas motor vehicles.
There you go. Sure.
Because it's harmful to the environment.
Well, that could be a subject for another program.
Under a different theory of logic.
Right. Now, I think it's also worth noting that the Federal Bureau of Investigation actually did a study of all the shooting incidents involving agents ever since there was a famous or infamous shootout in Miami in which several agents were killed and wounded. The two perpetrators were ultimately also killed by the agents. But as a result of that, the FBI started to examine the effect of different types of weapons and different calibers. They originally went to a 10-millimeter round, which was really too powerful. Many of the agents couldn't qualify with it. They then went to a .40 Smith & Wesson caliber, which many police departments still use. And they have actually gone down and said, look, their study shows that in every instance where agents have been involved in a shootout, only 10% of their bullets hit the intended target. And only 2% of those hit a vital area, namely that will disable the person, the brain, the spine, or the heart. And these are agents that are obviously well trained and have unlimited resources to practice with. And that really says something about the need to be able to, as many people point out, you have to be able to defend yourself. And if you're limiting the number of rounds that someone has, it really is handicapping the law-abiding citizen. And that's one of the arguments I think that's very frequently made.
Yeah, absolutely. I mean, these are very high-stress situations when this happens. It's, you can do one thing at the range, and you can shoot perfect the entire time, and then, when the moment comes, these are not easy situations to deal with. People don't make, sure shot decisions every time.
Yeah, and under stress, it's very common that multiple rounds have to be fired, even by police officers, which is evidenced.
Well, you see it all the time on the news too,
yeah.
On police body cams whenever they do I think there was a raid, in Providence a couple months ago. I think there was an active shooter situation, and you could see the police body cam. And they fired quite a few rounds, yep. So they're not being limited.
Right, and their training is to shoot until the threat is eliminated. Mm-hmm. The ruling came down on December 14th, 4 days before the due date, or the date of enactment. Attorney General Nerona immediately had a warning on his website saying that these are the consequences if you don't follow the law. So it seems to me that he was quite prepared in advance for the judge's ruling and coming down that quickly with a warning.
Well, generally speaking, by just the scenario of the entire thing, the state passed this law, and the state was defending this law. So generally, anytime you challenge a state law, they're somewhat confident that they can poke a win unless it looks really, really bad, at least at the district court level.
In the footnote to the judge's decision, I'm not sure if this is part of the law, but he says that people could surrender their magazines to the police department. If they identify themselves, the police department is supposed to store them. In the event that the ban is ultimately overturned, they could return them. You could also do it anonymously, obviously, and they would just be destroyed. Mm-hmm. I guess my question is, do you know whether or not the law or anyone has come out with instructions as to how the police are supposedly to store these magazines and catalogs?
Well, I believe they would store just by name and address, and just store it for a period of time where it's decided on the merits. I don't. If the law was declared unconstitutional, then they would probably have to return them, and I'm sure the police stations are storing them properly based on, those parameters. But there is concerns, and this was part of the problem I had with that whole procedure. When you're now giving the police station something that was once legal that is now a felony punishable by 5 years, people don't want to give the police their name.
Well, sure, and then you might go to some police departments like on Block Island or in one of the smaller towns in Rhode Island where there's 1 or 2 officers and a chief of police, and they have to catalog these things and store them. And that's why I asked the question. And the other reason I asked the question is that the so-called red flag law that was passed in Rhode Island specifically says the state police were supposed to issue guidelines for the local police departments on how these firearms that are confiscated under red flag law are to be cared for, stored, and so forth. We have made several attempts to find out from the state police whether they've done that, and we have not been able to successfully find out. So see, they have a law there that says you're supposed to do it, but doesn't seem to be having the proper effect. So, I mean, that's why I asked the question about guidelines, because it's simple to say, okay, here I have 3 of these magazines and my name is Richard August and you take care of them for me, but there's no guidelines. What does take care of them mean?
It's a great question. I don't know what it means. I don't know if they're keeping it in a box with your name on it in the back room, or if they're...
So as far as you know, there's no regulation, there's nothing in the law that specifically says this is what you're supposed to do. Or his decision did not give him any guidance. He merely said this is what you could do, as I understand it.
Yeah, that's pretty much what happened in the decision. They kind of worked it out, and in the next few days after that, they established the procedure for it. It was always understood, even prior to the passage of the bill, that you would be able to turn it into pretty much any law enforcement in the state police or any of the police stations in the municipality.
The decision has been appealed to the First Circuit Court of Appeals, and it will be handled by a co-counsel attorney, Paul Clement, I believe his name is. Was he the attorney, the lawyer that actually successfully argued the Bruin case?
Yep.
Okay, so he's obviously has a good constitutional law background.
Very.
I believe that he is supported by the National Shooting Sports Foundation in Washington, D.C.
I believe so.
Okay. This is an appeal of Judge McConnell's ruling on a motion for preliminary injunction. I keep repeating that because I think there's a misimpression in the community that Judge McConnell's ruling was based on the broader issues that would have been brought out at trial, which is not the case. It's a ruling on a specific motion.
Correct. Yeah.
So obviously it makes no sense to go to trial in a courtroom if the judge has already issued a 59-page decision on a motion.
Like I said earlier, it's a little, just real quick, it's a little different from normal cases because his decision essentially was a decision on the entire merits. It's usually not like that when you go for a preliminary injunction. So this is kind of a unique case.
So explain to our audience what happens in an appeals court and how it differs from the trial court.
Well, so an appeals court, in this situation, they review the record of the decision. They basically review Justice McConnell's ruling on it, and essentially, you know, if he followed the proper standards and if it was a constitutional decision. At this time, I have to be a little careful because it's still a pending appeal. But essentially what we're doing right now is we're in the beginning stages of the appeal, kind of getting everything perfected so that we give the proper notice, enter the proper appearances, and then just, you know, make sure that we're prepared for this. Make sure we're prepared with co-counsel and make sure we really particularly address all of the things that were really at issue in the denial of the preliminary injunction at the district court stage.
So at an appeal, you really don't introduce witnesses and you don't introduce new evidence. You're really going to the appeals court and saying, we believe that the judge at the trial level made errors either in judgment or interpretation of law, or that's the reason for the appeal. This appeal has been filed, but there's no set time in terms of hearing this appeal, is there?
That's a good question. I think there might be. We're still kind of in the beginning stages of it, so we're in our time limits right now for what we're doing in terms of perfecting the appeal, so making sure notice goes out properly and making sure the proper parties are entered. At that point, then we'll start to look into, you know, the timeline for it.
People, I think, that aren't familiar with the way the court system works are under the impression that everything goes like clockwork, but it really is a paper chase. The wheels of justice grind slowly, if I remember the expression. Mm-hmm. And so even you have to be careful to observe the time limits for certain things.
Yes.
Otherwise, the judge or the court will say, you missed the deadline. So
correct, yes.
And in fact, I think and Judge McConnell actually threw out some written testimony because it didn't come in on the right time frame. Mm-hmm. If I saw it, he did, yeah. So he did. You missed the time frame, you're out of luck. Mm-hmm. So I understand that there is a case that you may or may not be familiar with. It's a West Coast case, which would mean it'd be in the Ninth Circuit Court of Appeals. And there was some ruling that related to high-capacity magazines and whether or not they were constitutional. But I guess my question is, if the Ninth Circuit rules, let's say they uphold a ruling that the ban is unconstitutional, and the First Circuit then upholds McConnell's decision, this is where you get to the Supreme Court level. And the Supreme Court then has to decide or make a ruling as would be a national ruling because there's two circuits that are in disagreement. Is that?
Yeah, and that's usually when, so the Supreme Court generally, they receive a lot of what's called writ of certiorari, which is basically an appeal from the Court of Appeals. Mm-hmm. They hear a very minimal amount. Yeah. And the ones that they do hear very often are when there are constitutional issues where there's a circuit split. Mm-hmm. So where you have two circuits that come out completely different. In this case, that might happen. You know, the concern initially with this was that the states that are passing these forms of these bills, these anti-magazine bills, are all the states who are kind of located in circuits where they pretty much will uphold it, historically too. Yeah. I mean, the Ninth Circuit is deadly to firearms challenges. It's where it's where firearms challenges go to die, as I say. But yeah, so. But in this case, Oregon is kind of an interesting outlier, and I can't say that I'm super well versed on that decision, but I believe what happened is the judge essentially did not deny the preliminary injunction. He didn't make a determination on the constitutional issues of it, but I think he issued a stay on it, if I'm correct. And don't quote me on that because I briefly read about it, but he at least showed some, contemplation as to the constitutionality issues of of these magazine bans. It's been tough to find, because like I said, Texas isn't enacting these regulations, so it's not going to get appealed to their circuit.
Right.
So it's kind of tough to find a place that, is going to come out different on one of these than the others.
And it's also, I think, worthy to note, at least my understanding, again, as a layman, that when a writ of certiorari goes to the Supreme Court, which says, we'd like you to hear this case, they have to get 4 justices that say, we'll take the case.
I believe, I'm not totally sure, but
okay.
That's a good question.
Yeah. It doesn't have to be a majority. So you have Clarence Thomas, Justice Thomas, Alito, Kavanaugh, Amy, Conan Barrett. So there's at least 4 of them that would seem to be inclined to hear these matters, where in the past they couldn't very often get 4, to do that. So,
just an interesting point too that I just want to bring up as well is that when the Bruen decision was decided this summer, there were several cases pending in the Supreme Court on the magazine ban issue. When Bruen came out, the Supreme Court took all those cases and basically remanded them back. Well, not basically, they did remand them back to the lower courts and said, basically, reconsider this or uphold it based on the new standard established in Bruen.
So we have about a minute left, and I have a final question. The law in Rhode Island allows retired police officers to own high-capacity magazines. And I know from listening to General Assembly testimony over the years that this is really to garner the support of the Rhode Island Chiefs of Police and the FOP. Has anyone asked why a retired police officer needs to have a high-capacity magazine?
I would appreciate the answer of they did their service, so they're entitled to that. I would appreciate that much more than the answer of they're trained, because everybody who has a concealed carry permit for the most part is trained. I'm trained. Yep. A lot of other people are trained, and they're not afforded that same privilege.
Well, this ban has been on one of the high priority items for the gun control legislation crowd for a long time, and it seems likely that we'll see an assault weapon ban passed in Rhode Island based on Governor McKee's comment. When that happens, there'll probably be an appeal, but when the appeal comes down, we would certainly like to have you come back and we can discuss what the First Circuit has to say about all this.
I'd love to be on, even if I'm just commenting on the new case that's filed.
Okay, and thank you for our audience for watching State of the State for a very timely and interesting topic.